for. I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of an attempt to commit theft of property, find that prior conviction true, or the prior convictions true in that case, sentence you to a term of 20 years in the institutional division of the Texas Department of Corrections.
2 felony convictions, a 20-year cap, and a defendant whose criminal record stretches all the way back to his teenage years. Today, we're breaking down a sentencing hearing out of Jefferson County, and by the end of it, you'll understand exactly why this judge had heard enough. Floyd Torin is standing before the court on 2 charges. Attempted theft, enhanced to a second-degree felony because of his prior record, and evading arrest with a vehicle, also enhanced. He's already pled guilty. The only question left is how many years he's going to serve, and that's where this hearing turns into must-watch courtroom drama. His defense brings up real, sympathetic factors: declining health, vision problems, documented mental health treatment, a family sitting in the gallery, letters of support. On paper, that's the kind of mitigation that can sway a judge toward leniency. But then the prosecution lays out something much harder to look past. This isn't Torin's first offense, or his 5th. It's his 11th and 12th felony. And he committed both of them less than 2 years after getting out of a 15-year prison sentence. Then comes the detail that changes the entire tone of the hearing. The evading charge wasn't just a car fleeing police. We're talking near misses with other vehicles at 2 separate intersections, a fence plowed through, and a chase that kept going even after the crash. Stick with us, because how the judge weighs a genuinely sympathetic backstory against a genuinely terrifying police chase is exactly the kind of sentencing decision that sparks debate. And we want to know where you land on it.
Okay, you're Floyd Torin, and this is cause numbers 25 DCCR 0974 and 25 DCCR 1152. Mr. Torin was previously in court, entered pleas of guilty to attempt to commit theft of property. It was enhanced to a second degree because of priors, and then evading arrest or detention with the vehicle, also enhanced to a second degree. I've received the pre-sentence report, and the agreement was for a cap of 20 years. It looks like it probably could have been habitual, but you guys pled it to just a straight second degree with an open plea to the second, correct?
Yes, ma'am.
And I've received the pre-sentence report as well as some documents that Mr. Radford has sent in with regard to Mr. Torin's mental health, as well as some physical issues, and one letter as well of support. Have you both had an opportunity to review all of that?
Yes, ma'am. Yes, Judge.
Are there any additions or corrections to that pre-sentence report?
Just the things that I submitted, Judge.
Okay, Mr. Radford, you may proceed.
Judge, Mr. Torin has an extensive criminal history. However, as he has gotten older, he has had some health issues. He has vision problems. He has been seen and treated at Spindletop MHMR for some mental health issues. He has a very supportive family who is here today, and I'd ask that the court take that into consideration in determining his sentence.
What is the status of parole?
No, wait on the way.
This.
Okay.
Mr. Smith?
Judge, his extensive criminal history going all the way back to his juvenile years tends to show more about what he is and what he does than anything else. He's been given probation. He wasn't able to complete that. He has been sentenced to multiple long sentences in prison, and that seems to be the only thing that has kept him from committing new crimes in society, was the fact that he was incarcerated. I don't feel like probation is appropriate. We would ask for, we have given him consideration by coming off of the habitual and capped this at 20 years. So we would ask for TDC sentence in the high range on this.
Mr. Torin, in 2019, you received a 15-year sentence. So you were only not I don't know how long it doesn't show me when you got out or how long you were in on that, but obviously,
I got out of one night of 23.
so you got out in 2023 and less than 2 years later, you've got 2 more felonies, which add up to your 11th and 12th felony offense. And I understand the issues with PCP. It looks to me like that's more of an issue than anything else. I understand there's some mental health issues, but you, as a grown man, have had every opportunity to get help and try to get in TDC, out of TDC, to live your life outside of prison, and you've chosen not to do that. Your only time clean is when you're in custody. That's what you told the person doing that substance abuse assessment. I don't know. I just think it's I appreciate your family being here, and I appreciate the support, and I appreciate this letter, but it's all ridiculous when you look at your criminal history and the fact that you're on parole and you commit 2 more offenses and you're still using drugs, and you haven't it's not like you're a young kid. You know what you need to do to get the help you need to get. And you've made a conscious decision not to do that. So at this time, in cause number 25 DCCR 0794, and this evading was crazy. I mean, you could have killed people. You got used, I think it was twice you almost struck intersection of Interstate 10 and 7th Street, almost struck another vehicle. And then again at 7th Street and Dollinger, you almost struck another vehicle. You crashed through a fence. Then you continued to flee after you crashed through a fence and crashed again and finally came to arrest. I mean, it's not like you just kind of sort of evaded. Your behavior is just a danger to everybody here in Jefferson County.
This is the moment the judge stops weighing mitigation and starts weighing public safety. And it's worth breaking down why. Courts genuinely do consider things like age, documented mental illness, and substance abuse history at sentencing. That's not performative. It's built into how presentence reports work. But mitigation isn't a free pass. It gets weighed against aggravating factors. And few things weigh heavier than an extensive felony history combined with a chase that endangered bystanders at multiple intersections. Notice also what the judge zeroes in on. Torin's own statement to the substance abuse evaluator that his only clean stretches happen in custody. That's a detail the defense probably wishes hadn't made it into the record, because the judge uses it almost as evidence against the leniency argument itself. If freedom consistently leads back to drug use and new felonies, what does probation actually accomplish here? Do you think the judge is right to treat that admission as decisive, or is that an oversimplification of addiction? Let us know what you'd have weighed differently.
So that being said, 25 DCCR 0794, I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of an attempt to commit theft of property, find that prior conviction true, or the prior convictions true in that case, sentence you to a term of 20 years in the institutional division of the Texas Department of Corrections. And cause number 25 DCCR 1152, find also sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Find that prior conviction true, sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Correction. You will receive credit on each of these sentences for any time that you've been in custody that the law gives you the right to receive. I'm handing you, and they will run concurrently, which means together at the same time. I've handed you the trial court certification that shows these were agreements. I followed. You've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. Read that. You should already understand it. But if you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Radford. Right, you can go back with the bailiff.
Maybe
The judge details the dangerous police chase before imposing a 20-year prison sentence. If you enjoyed this courtroom breakdown, be sure to like the video, subscribe to the channel, and we'll see you in the next one.
So here's where it all lands. 2 20-year sentences, running concurrently, for a man whose criminal history now spans 12 felonies and multiple prior prison terms. The judge didn't dismiss the mitigating evidence, the health issues, the mental health treatment, the family support. She acknowledged all of it. But she also made clear that sympathy only goes so far when someone gets out of a 15-year sentence and, within 2 years, endangers the public in a high-speed chase through Jefferson County. This case is a pretty clear illustration of how sentencing actually works in the real world. It's rarely just about the current charge, prior record, patterns of behavior, and the specific facts of how a crime unfolded. In this case, near collisions and a fence crashed through mid-flight from police, all factor into where a judge lands within the agreed sentencing range. Torin waived his right to appeal as part of the plea agreement, and he now also carries a permanent federal and state restriction on possessing firearms or ammunition because of these judgments. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.